Okay, so now we're going to talk about criminal law, and obviously the most common that people tend to have issues with is DUI, driving under the influence, driving while intoxicated. The terminology differs by state. It's state law, but usually it's any type of criminal defense. So the first thing that I want to tell people is that a lot of times people immediately say, okay, my spouse just got arrested. I need an attorney immediately. I wouldn't say that you don't need an attorney, but the majority of times, once someone gets arrested, they're just going to be processed, booked, and unless there's going to be like a bail hearing or an arraignment and they're stuck in custody, meaning they're stuck in jail pending that hearing and the results of that hearing could be very important to where maybe you do need an attorney immediately and you'd look for a criminal defense attorney in your local area. However, the majority of cases, someone gets booked, maybe processed, fingerprinted, photo, whatever the police department does to process them in that area. And maybe they'll say what the potential charges are. They're usually not actually charged. They'll just say, well, they're probably going to be charged with a DUI. They'll set a bail amount, either nothing, released on their own recognizance, and you're let out of jail a few hours later, or maybe they set a bail amount, $500, $10,000, $20,000, whatever it is, and you have to post that bail. So it's usually almost better to talk to a bail bondsman in your area to start working on arranging that potential bail versus an attorney, because the attorney may not really be able to do too much for you until there's actual court proceedings, meaning hearings, something in front of a judge. So unless you're in an area where they take you the next morning or some other time for an arraignment and a bail hearing, where you really should have an attorney no matter what, then otherwise usually just maybe talk to a bail agent, wait till they're released from jail, and then find out what the charges are going to be, and then evaluate your options. Because usually at that point you have a lot of time, even though initially you're freaked out because, my friend, my spouse, whoever just got arrested, they were driving under the influence or whatever it is. And so now they're in jail. What do I do? Usually it's give it time, post bail, and then figure out what your options are based on what the charges are going to be. And those may not come for, in some cases, they can be a year later before charges are filed. Usually it's within a short period of time, a few weeks, you'll get charges and you'll find out an arraignment, which is your first hearing. They'll usually schedule that arraignment when they release you from jail in most cases. So they'll say, okay, come back in 3 weeks on this date at this place for your arraignment, which means you're brought in front of a judge and you have to enter a plea of guilty or not guilty, like you see on TV. And basically you go in there and you can just say not guilty, and then they'll postpone it and they'll give you another time frame. Now, depending on your state law, in terms of criminal law, there are certain waivers you might be able to do of what's called waiving time. So normally criminal cases have due process requirements and timing. So a lot of times they may have to bring you to trial within a very short period of time because it's a criminal case and it has such a major impact on you. So you may have to, the judge may say, okay, well, if you want to plead not guilty and continue this hearing to 3 months from now, you may have to waive or give up the right to a speedy trial, for example. And so you would just say, yes, I waive my speedy trial right. And they'll set a hearing in 2 months or 3 months for the next either arraignment, preliminary hearing, whatever they do in that specific court. And that gives you also more time to figure out what you want to do. You can potentially plea bargain or agree with a prosecutor to I agree to plead guilty to some type of charge or maybe a lesser included charge. So if maybe it's grand larceny and you are willing to plead guilty to something lesser like petty theft, and you negotiate that with the prosecutor at your hearing, or you call them and then you say, okay, well, what will you drop it to? And you give them some mitigating factors, meaning, okay, hey, here's all the things that led up to this. I didn't mean to do it. It's a first time offense, that kind of stuff. And then see what they'll offer you in terms of the prosecutor, if you want to take that or not. And you could always run that by a local criminal defense attorney, and the criminal defense attorney might be able to tell you, I'm in front of this judge, I deal with that prosecutor all the time, I can get you a much better deal, or maybe they can't. So you can make that decision kind of during that process and say, okay, well, do I want to pay an attorney to represent me? Maybe I'll get a better deal, maybe I won't. Usually they'll either do a flat fee. A lot of DUI or criminal defense attorneys do a flat fee, like, okay, your first DUI will charge you $3,000 to handle the whole thing. Or usually it's not hourly, but some do. So it could be $200, $400 an hour, or a lot of criminal defense for certain misdemeanors or a couple $1,000s to handle the whole case for you. And that's usually means through a plea bargain, meaning you're going to agree either that it gets dismissed or you're going to agree to some kind of lesser charge and agree on a certain sentence, like I'll pay this fine, or I'll serve a day in jail, or I'll go to AA meetings, or whatever it is, to resolve the case. Hiring an attorney I want to make it clear, hiring an attorney rarely will just make the case go away, unless they did something seriously wrong by the police. And that's pretty rare where that actually happens to where they completely dismiss the case. Usually to do that, you have to go all the way to trial, which can cost time and money. And I do not recommend going to trial in a criminal case by yourself. Usually if you're going to end up going to trial, that's usually at a point where either you plea bargain down and agree to something, or you hire an attorney to take you to trial, because you're dealing with evidentiary issues, and whether potential rights were violated during the process. So that gets pretty technical and pretty complex. Certain pretrial motions, what witnesses you can bring. Anytime you're talking about a trial, that's usually a little too complex to represent yourself, and you'll see evidence of this on TV when they do like World's Dumbest Criminals or whatever, where they represent themselves to defend themselves from a murder trial or whatever, and it usually goes horribly, horribly wrong. So if you're going to go to trial, hire an attorney. If you're going to plea bargain, see what the best deal is you can get. And hiring an attorney may or may not get you a better deal. If some attorney says, I'm going to get you a better deal for sure, guaranteed, they're probably full of it, just in my opinion, because you can never guarantee what kind of deal you're going to get. All they can do is say, hey, I handle 20 of these a day and I negotiate them all the time. Here's what's the most common for the situation you're in within this range, and that's what I should be able to get you. That's more reasonable. If they say, I'm going to get this dismissed because I'm going to run your blood tests, and did they do a blood split? Did they do this? Did they do this wrong? Did they advise your rights at this point? Most of the time, those are things that they'll look into, but from what I've seen, it's pretty rare that it actually leads to a complete dismissal of the case. Usually it's just something that can help negotiate the case and maybe get a better result. So if it's a misdemeanor, see what you can do for a plea bargain. If you're talking about a felony, and they'll tell you that when they charge you, what you're being charged with, whether it's a felony or a misdemeanor. If it's a felony, you got to take that more seriously because there's a much higher consequences to it. Doesn't mean you automatically have to hire an attorney for that, but I would say misdemeanor stuff, you can probably try to plea bargain on your own. In most cases, felony, or if you're going to trial, you probably really should have an attorney to help you out at that point. So that's for criminal defense. If you're going to trial or if it's a felony, you should probably hire an attorney. If it's a misdemeanor or early in the case, you can maybe represent yourself, or at least continue the hearings out far enough to see, what's going to potentially happen and what the potential plea bargain is, and see what you can do on your own. If it's not going well, maybe talk to an attorney at that point, and they're probably going to charge you a flat fee to help represent you all the way through a plea bargain, or a set fee for a trial. So that's criminal defense.